I wonder how color trademarks work if you're colorblind. Hi, I'm Andrei Mincov, the founder of Trademark Factory, and in this video I'm going to share my thoughts about yet another trademarking screw-up. This time around, it's a new fashion brand trying to trademark color green for soles of shoes. Let me read it from the article, and you can always find the link in the description below. But a young brand wants to register its green sole as a trademark and is using Louboutin's drawing to do it. Couple of things going on here, so let's keep reading. One way to build a luxury shoe brand: paint the soles a single color, position them among the likes of world-famous figures on red carpets, in fashion editorials, and on the biannual Fashion Month runways, and then wait for demand to skyrocket. This is the tactic that Reginald Louboutin adopted back in 1991, and as a result of which, the French footwear company has sold more than 1 million pairs of its $700 plus heels, sneakers, and flats, all of which bear a distinctive lacquered Chinese red sole. The red sole and its ability to identify a single brand has enabled Louboutin to amass trademark rights around the world and has seemingly caught the eye of a fellow footwear brand, one that has also sees the effectiveness of and the value in a colored shoe sole. That brand, Reginald Bendolph, is seeking to claim federal trademark protection for a green shoe sole, according to an application for registration it filed with the U.S. Patent and Trademark Office, USPTO, early this month. The newly filed trademark application claims that New Jersey-based Reginald Bendolph maintains rights in the product configuration color of a shoe sole mark in the specific color green, citing the brand's first use of a green sole on shoes in March 2017 and including an image of the green sole on a pair of black ballet flats. Beyond that, the brand's website currently offers an array of footwear, including a pair of shining black calf leather pumps with the same green sole, which will set you back to $100. Look at this picture. To the left is Louboutin's trademark drawing. So this is what Louboutin used in his trademark applications to claim the right to the red sole. And this is Bendolph's trademark drawing in their trademark application when they're trying to claim color green as their trademark. Now, there is something more interesting at play than whether Bendolph will be able to make a case that consumers associate green color shoe sole with a single source that is, after all, the essence of trademark protection. I would be willing to bet that the little-known brand, which has not been using the mark for very long, does not appear to advertise, is not the subject of widespread third-party media attention, is not being preyed upon by copycats, that is, some of the factors used to prove the necessary secondary meaning for the protection of non-distinctive trademarks, will have a hard time with that. Now, I'm gonna get to that in a moment, but let me just keep reading for now. Every trademark application must include a clear drawing or depiction of the trademark that the applicant is seeking to register so that USPTO's examining attorney can determine what exactly the trademark is. And the drawing included with the Bendolph's application shows a green sole, that is the trademark, on a strappy high heel sandal. While Bendolph is not claiming rights in or seeking protection for the design of the sandal itself, with its covered stiletto heel, crisscross ankle strap, and thin strap that bands the open toe of the shoe, the drawing is striking nonetheless. That is because it is an almost exact replica of the drawing that Louboutin used for the July 2007 application it filed with the USPTO for its red sole trademark. given that one of the bars for trademark registration with the USPTO is confusing similarity with an already registered mark, it's worth asking, even if Bendolph could show that its green sole had amassed distinctiveness by way of secondary meaning, or that consumers, upon seeing the green sole, do associate it with a single brand, will the brand be blocked by Louboutin's existing mark thanks to the marked similarity of the drawings? The answer? Almost certainly no. I agree with that. From a trademark point of view, that's not confusing, as the representation of the shoe in Louboutin's drawing is technically not part of its registration claim. So let me explain what this actually means. I just show the image again. Do you see this dashed lines? So with trademark applications, when you have a drawing and some of it is dashed lines, that means you're not claiming the shape of what's shown with those dashed lines. Is just an example of what it could be generally. The only thing that Louboutin tried to protect with this drawing is the sole. And the idea behind was that it can be any shoe. It could be high heel, it could be not high heel, it could have straps, it could have open toes, it doesn't matter. We're putting them in dashed lines to show that we're not claiming this particular shape of the shoe as our trademark. What we are claiming is the color. And same thing happens with the green sole application here. All dashed, you see? Okay, so let me go back. In other words, in its since approved application, which was slightly modified from its original form following the outcome in the case it filed against Yves Saint Laurent in 2012, Louboutin does not claim or enjoy rights in the sandal design, exactly what I said, just the color and placement of the mark. Yeah, so the color and where it goes, the sole. Moreover, the colors being claimed by the two brands are obviously different, so there's no trademark confusion, right? The one is just for the red sole, the other one is for the green sole. And from the trademarking perspective, there is nothing else to look at. Now, as for whether Bendolph's trademark application, thanks to its use of a drawing substantially similar to Louboutin's, gives rise to a claim of copyright infringement, this is another matter entirely. Now, and this is actually an interesting matter because I wouldn't be surprised if what happened was they said, the client brought this to their lawyers and said, we want to trademark the green sole. What are we going to do about it? And of course, the lawyers know that Louboutin's got red sole trademark because every trademark lawyer knows this. Every trademark attorney knows this. It's kind of a textbook example of trademarking color, right? There's that, there's magenta color for T-Mobile, there's maybe a few more, the Tiffany blue, but really there's not that many famous color trademarks. So like, okay, Louboutin did this before, and what they did probably is they looked up the application that Louboutin filed and was successful with, and they modeled it to file a same or very similar application for Bendolph. So at some point, they looked at the design that Louboutin used and they creatively redrew it, let's put it that way. They borrowed inspiration from Louboutin's drawing. Well, they had access and they are substantially similar. So let's assume that there is copyright infringement. There's a couple of things to think about. First of all, who owns the copyright in the original drawing, right? The original drawing with dashed lines and the red sole. I wouldn't be surprised if that was some clerk with a law firm that works for Louboutin, that when they got the request, let's file this trademark and protect the red sole, they had somebody draw a sandal that looked kind of like a sandal, put it in dashed lines, set the sole with color red and said, this is what the trademarks office is going to accept. Can we file it? Yes, good. Now, from the copyright perspective, it's the author of that design that owns copyright, unless, of course, there was an agreement that anything that is created by that law firm is automatically becoming intellectual property of the client. And I wouldn't be surprised if they don't have such an agreement. So it might be a name that nobody really even knows. But let's forget about that. Whether they can track this down and get the proper paperwork, or maybe they already have the proper paperwork. Now the next question is, if it is copyright infringement, what could they do with it? What could they do with it, right? It would not prevent the registration of the trademark at all. And all it would do is lead to the question of how much damage did Louboutin sustain because of that copyright infringement? Or even if it's statutory damages, if somehow somebody registered that design as a copyright, which I don't think anybody did, and if they didn't, then you couldn't use statutory damages. So really, the damages there are minimal. It's what's called the de minimis defense, that this new firm would say, look, yeah, we may have gone a little bit too far with our inspiration that we took from your design when we designed ours, but really, what did you lose? We're not selling the design, we're selling shoes. Shoes are different. We're not copying your design. Yeah, we were inspired by your idea, but hey, think about this. When somebody files a trademark application, do you think they will always draw it from scratch? Of course not. Every trademark attorney, when they see that they have a new client and this new client's got some very interesting product or interesting service, something that's not necessarily easy to classify, what they would do is they'll look up the trademark registry to see who's filed similar trademarks before, whether approved. And then if they were, they would carefully read that, the statement of goods and services, they would look at the description of the mark, and they would again creatively rework that into the application for their client. That's what attorneys do. You shouldn't expect every single trademark application to be drafted from scratch. Nobody does this. So I guess this was exactly the case here, and we'll see how far this goes. But now there's another issue here. There's another issue here in terms of colors, trademark colors. Right? You're not supposed to just claim, oh, I like that color, that'll be my trademark, which is the point they make in the article. Right? You have to show secondary meaning. You have to show that this is the color that the public at least can associate with you and nobody else. And because otherwise they would be just saying, well, I want green, I want blue, I want black, I want white, I want whatever, right? And very soon we'd run out of colors. And that's the complaint that we hear from people who don't know how trademarks work. Like, how can you own a color? Right? It's not about owning the color. It's about owning the mental link between that color and your products and services. So if you can establish that, you can trademark that. If you can't, you got a problem. Now, I hope you found this video interesting and useful. And if you did, subscribe now, get notified whenever the next one goes live. We post them every single day. Now, if you got a brand that you want to protect, whether you want to protect the color, whether you want to protect the shape, whether you want to protect the name, whether you want to protect the logo, whether you want to protect the tagline, whether you want to protect something that sets you apart from everybody else who does exactly the same thing you do or something similar to what you do. And the brand plays a really important role in your business. If that's you, go to trademarkfactory.com, book a free call with our strategy advisors, and they'll help you figure out what to trademark, when to trademark, how to trademark, and all of that you'll get for free. And if you're a good fit, we'll help you do that. Until then, I'll see you in the next video.